What is privacy? Is it about keeping information secret from others, or about protecting some sort of personal sphere, like in your own home, or maybe not being seen naked by others, or perhaps something else entirely? Whenever we talk about privacy, it's normal to begin by pointing out just how tricky a concept it is. That is, it's hard to pin down and provide an exact definition for it. But just because the concept of privacy can't be easily defined in some straightforward way doesn't mean that we can't learn a whole lot about it by looking at how attitudes to privacy have developed over time. After all, every country in the world legally protects at least some aspects of privacy, and the scope of these legal protections has grown over the decades and centuries. In other words, we can appreciate current attitudes toward privacy better if we see where they've come from and where they seem to be headed. So let's do just that by talking a bit about the legal history of privacy. Now, there are a few things we need to go through right here at the start just to make sure we're all coming from the same place. And the first is to say a few words about how and why the law grows and develops and changes over time. And, well, the simple answer is that the law develops to deal with the things in a society that the people are concerned about. Not just anything, of course, but those things that enough people are concerned enough about. So, for example, it used to be that not enough people were concerned enough about the well-being of children. Therefore, there weren't any laws protecting children, and so they were widely abused and exploited and put to work in dangerous factories and dying or losing limbs in horrible accidents and so on. However, as time went on, enough people became concerned enough with the well-being of children that countries started making laws forbidding child abuse and child labor and so on. And this is not just in the past either. We're living through these sorts of developments today as well. For example, an increasing number of people are growing more and more concerned about the climate, and so there's a push for this to be reflected in the law. What will the ultimate outcome of these developments be? Right now, who knows? But like in the case of child labor, there's a good chance that our kids and grandkids will look back on whatever laws do take shape as long overdue and morally necessary. Now, so far, this should all be pretty obvious to everyone. The law changes in ways that reflect the ongoing concerns of the people, slowly and reactively, sure, and sometimes not really going far enough, but it still tends to track the sorts of things that the people tend to be most concerned about. In this sense, the law is a bit like me trying to make sense of my kids' slang. By the time I figure out what sus or side-eye or skibidi toilet mean, they've already moved on to new words, and so I'm always a few steps behind the latest developments, even when I'm doing my best to keep up. So that's the why, but what about the how? How does the law develop over time? Well, very basically, we could say that the two major sources of legal developments are legislation and precedent. So let's talk a little about each. Legislation is what happens when lawmakers, such as elected politicians, make new laws. This happens in pretty much every legal system in the world, but is the most important and fundamental source of law in so-called civil law or Roman law systems. This is what we find in most of the non-English speaking and non-Islamic world. In these civil law systems, lawmakers first make laws, and then the courts hear cases and try to decide them according to the laws. The courts usually have some freedom to interpret how the laws apply to any individual case, but for the exact same reason, the final court decisions don't usually hold that much weight for other future cases in other courts. Precedent, on the other hand, is when court rulings are bound by previous court decisions, especially decisions that come from the higher courts in the country. And although civil law systems will put a little weight on how previous cases have been decided, it's an absolutely fundamental source of the law in so-called common law systems, which is what we find in most of the English-speaking world. In these common law systems, courts not only interpret existing laws in a way that's strongly binding or highly persuasive on later cases, they also have the ability to develop entire areas of law where there is no legislation of any kind, just by looking at the precedents set by the previous cases. On the one hand, this makes the courts in common law systems far more powerful players in actually developing the law compared to the courts in civil law systems where they only apply it. On the other hand, it can also sometimes leave common law court decisions a little more uncertain and open to interpretation than in civil law systems. In fact, when reading common law case reports, you can often vaguely hint the outline of some general legal principle that arises out of all the cited cases together, rather than from any single case, but where it isn't actually written out. At least at first, this sort of principle only really exists in the minds of the judges and legal scholars and others working on understanding the cases. In this sense, it can sometimes feel almost like poetry. You only really catch glimpses of the real meaning somewhere behind the words of the case reports themselves. Okay, so legislation and precedent are both sources of law. Legislation comes from lawmakers, while precedent comes from the courts. Civil law systems depend primarily on legislation, while common law systems lean more equally on both legislation and precedent. Now, for either source, the law still needs to develop according to what the people are most concerned about. But the way these concerns feed into the law is different for each source, in a rather interesting way. When it comes to legislation, in both civil and common law systems, the question is how lawmakers keep track of what the people are concerned about, so that they know what sorts of things to make new laws about. Sometimes, of course, they're elected on a specific political platform profile, so as soon as they gain enough power, they start making laws related to their profile issues. That's what they promise their voters, after all. Other times, the people's concerns come up more organically, in a way that no party or politician is at first profiled for or against, but which still needs to be dealt with, like the rapid development of a new and potentially harmful technology. So, for example, think AI and all the current worries that lawmakers around the world have about it, even though it wasn't really any sort of concern for anybody around 10 years ago. But basically, the people get worried, and once their concerns grow large enough, the politicians have to start looking at it. Either way, whether it's about some specific profile area or not, lawmakers will look at legal scholarly research to make sure they get it right when they propose new laws. Or, well, the politicians themselves don't usually look at this research. After all, they were elected to lead, not to read. But they will typically have various advisory committees and specialist hearings and so on, so that their legal advisor nerds can bring them up to speed. So they'll hear summaries of, for example, academic articles where legal scholars argue for one point or another, like that two existing laws are in conflict and therefore need to be changed, or that some specific court case proves that there's some missing legislation that needs to be developed. And where the arguments are convincing enough, the lawmakers are then likely to start pushing for it in new laws. Now, when it comes to precedent, since it's developed by judges instead of lawmakers, then the way it tracks people's concerns is a bit more subtle. I mean, judges are people, and so their personal concerns will, over time, make their way into their court decisions. But they can't just arbitrarily decide whatever they happen to feel like at the moment. Since precedent in common law systems is binding, or at least highly persuasive, there's a crucial need to safeguard how it develops to ensure continuity and avoid outright conflicts between different judicial decisions. So, because of its emphasis on precedent, common law systems rely heavily on published reports of all important cases for future cases to rely on. These case reports usually include lengthy reasoning by the judge about why they reached a specific decision and on the basis of what previous precedents. These case reports are then pored over and picked apart by legal scholars. For example, they might try to develop a view of the hidden underlying general legal principles that arise from a collection of precedents. Or maybe they'll point out how some specific court's decision is actually in conflict with other precedents that the case may not have considered, or similar. And the scholarly work then has a corrective impact on the way the courts work. In their decisions, common law judges will often cite legal research when deciding cases as a way of backing up their reasoning. In other words, in common law systems, there's a sort of symbiotic back and forth between court decisions and legal research. The court decisions form the basis for what the research focuses on, while the research often becomes the basis for later court decisions. And back and forth it goes, like a high-level conceptual game of legal pong. Now, I mentioned judges' personal concerns just a moment ago, and although a judge should ideally be a neutral arbiter of the law, deciding cases purely based on their legal merits, of course, in reality, a judge will tend to lean one way or another. Again, judges are, and this is true, people. And, well, which particular pieces of legal scholarship a judge will find convincing can be quite personal and depends, at least sometimes, on their political preferences. Therefore, lawmakers, the politicians in common law systems, can have a long-term impact on the development of precedent by making sure to appoint judges that are sympathetic to their own political leanings. So by appointing more progressive or more conservative judges across the court system, the politicians try to make sure that future precedent develops in a way that's more in line with their own and their voters' political views. This is much less likely to happen in any meaningful way in civil law systems where precedent is not as important and binding. Anyway, in both cases, for both legislation and precedent, legal research has a large impact on the way the law develops. But what about the legal scholars themselves? When they're writing about some legislation or precedent, what do they use to build their arguments? That is, apart from the laws or cases themselves, what do they actually base their work on? Well, here comes a crucial point. When legal scholars are doing basic work on a wide-ranging and contentious topic such as privacy, well, then they tend to be quite concerned with what the concept of privacy really means. And for this, they will turn to philosophical research. Now, philosophers typically work on developing strong, robust concepts, but they don't usually care all that much about their applications in practice. Instead, it's normally the legal scholars who take the philosophical definitions and work with them to try to kind of translate them into possible real legal applications, whether in the form of explicit legislation or implicit precedent principles. And personally, as a philosopher by background, I have to say this is kind of neat. After all, who would have thought that abstract conceptual philosophy might actually be so practically relevant to, well, all of us? Not only that, but this is where it starts to get really interesting. You see, once the law develops, a sort of feedback effect can happen here. Because the law is a sort of baseline for everybody, this means that legal scholars, and yes, even philosophers, will often have stuff to say about new legal developments. So not only does philosophical research on some concept occasionally impact the form of some later real-world legal development, but the legal development will then itself become the focus of new philosophical and legal research on the same concept. So perhaps I define privacy some way, publish my definition in a philosophy journal, influence a bunch of legal scholars who then use my definition of privacy to suggest new legislation or some new interpretation of precedent, which then kind of bubbles up to lawmakers or courts who apply it in practice, which then gives me as a philosopher more real-world cases to reflect on in my conceptual work. It's sort of like if you jump onto some popular TikTok trend, like makeup tutorials, and make a bunch of your own. But, crucially, your makeup tutorials also smuggle in some political commentary about, let's say, abortion rights. If others then see what you're doing and start copying your format so that they also put in views on abortion rights in their makeup tutorials, then eventually, if it spreads widely enough, the whole meaning of makeup tutorial on TikTok will have subtly changed. Instead of just being about cosmetic tips, people start seeing makeup tutorials as a sort of coded reference to disguised political abortion commentary, which then forms a new baseline for what sort of content people are actually looking for when they search for the terms makeup tutorial, and which presumably also impacts your own future makeup tutorials. In other words, the meaning of the words shifts over time because somebody starts intentionally using them in a different way, and this then spreads to and is picked up by the wider community. So basically, in this example, philosophers are like the original abortion rights agitators, the legal scholars are the makeup tutorial TikTokers smuggling in commentary on abortion rights, and the lawmakers and judges are the 12-year-old social media consumers of the TikTok videos whose views on abortion rights are gradually shaped by the legal scholars. Okay, so the law develops in a way that tracks major concerns in society, and philosophers and legal scholars play an important role in how the law, whether in legislation or in precedent, develops its concepts. Then this directly determines what specific sorts of cases the resulting legal developments actually apply to. And then that very same legal development forms a new baseline for further conceptual and legal research on the topic, which again feeds into legal developments, and so on. When you think about it, and as my kids might have said, that's pretty slay. But now that we've got this overview of why and how the law develops over time, the question is how it actually developed historically in relation to privacy. And to answer that, we're going to take a trip to England toward the end of the 1500s, around the time that Shakespeare was just a little boy. Why start with England? Well, first because it's one of the world's oldest continuous legal systems, so it gives us a broader historical scope than almost any other country to investigate the development of legal privacy protections over time. And second, because it forms a historical basis for United States privacy law. And why is US law so important? Again, two reasons. First, because certain developments in the US during the 20th century led to by far the most extensive privacy research by both legal scholars and philosophers that the world has seen so far. And second, because no matter where in the world you live today, US privacy law still impacts you, in the sense that it, for example, regulates the behavior of big tech companies. So, like when Facebook stores and processes some of your data in giant server farms on American soil, regardless of where in the world you happen to be located. All right, let's get started. If we begin with English law, we can see early developments of legal protections of personal physical space and goods in relation to laws on trespass, nuisance, and harassment. Further down the line, English law developed protections against revealing some sorts of information about others. If the information was false, it would be covered by defamation law, while if it was true, it might be covered by blackmail law, or perhaps confidentiality law. I'm going to dwell on this last one a little, because it provides a great example of how English legal privacy protections have developed over time. To start with, in 1576, when Shakespeare was just 12 years old, English courts recognized the need to protect all communication between a lawyer and their client, so that your lawyer couldn't be forced to testify against you in court. Similar protections were established 3 years later between spouses, so you weren't legally required to rat out your husband or wife. Quite a bit later, in 1741, there was a famous case involving Jonathan Swift, the guy who wrote Gulliver's Travels. Anyway, the case found that even though Swift had sent a letter to somebody else, and it was, so to say, now that other person's physical property, they still couldn't publish the contents of the letter, as these were still Swift's. Basically, it was his ideas and words, and other people couldn't just use those however they saw fit, even if they now owned the physical letter on which they were written. More importantly, the 18th century also saw the development of various so-called duties of non-disclosure. This area of the law started small, but eventually grew over the centuries to a prohibition on breaking trust in a bunch of different legally recognized confidential relationships. So this would be things like that business partners couldn't steal ideas from each other and present as their own, or that academic journals couldn't publish lectures submitted by a student taking note without the lecturer's consent, or that a photographer couldn't use the photos from a private photo shoot with a paying customer for the sake of making and selling Christmas cards in his shop. But the really big case, arguably the mother of all privacy cases, was Prince Albert v. Strange from 1849. So here's how the case went. Prince Albert and his family, including his wife Queen Victoria, had made a number of drawings and etchings for their own personal use and amusement. Nothing salacious or sexy, mind you, just personal doodles. They then asked a royal printer to make copies of these. Without the printer's knowledge, one of his employees took some copies for himself. Looking to make a quick buck, he sold them, and they eventually wound up in the hands of the defendant, Mr. Strange. Now, Strange wanted to not only exhibit the copies to the general public, he also wanted to print a catalog describing them to potential buyers. The Queen and her husband sued for the prevention of the exhibition and the publication of the catalog. Since the case wasn't very obviously covered by either legislation or previous precedent, but kind of fit in under a general principle expansion of some previous cases, the court claimed an original and independent jurisdiction and found in the royal family's favor, arguing that privacy is the right invaded. Now, this is worth pausing for a moment to reflect on. I didn't mention it yet, but there is not, nor has there ever been, any general right to privacy in English law. There have been numerous attempts to legislate one in Parliament over the years, but they've never succeeded. So for the court in Prince Albert to argue that privacy is the right invaded was really quite surprising, and furthermore a stance that would later come to have a profound impact on US privacy law. I'll return to that in a moment. For the time in England, I guess it really helped to be the royal family. Even if there was no real legislation or precedent protecting you from some sticky situation, the courts could then just kind of invent a legal principle to keep you happy. Anyway, staying in England for now, by the dawn of the 20th century, privacy was protected by a patchwork of various different pieces of legislation and precedent rather than any unified single area of law. And the past 100 years have seen further refinements of this, which have helped clarify some really central features of these protections. One such important case was K v. Robertson from 1991. In this case, the well-known actor Gordon Kaye was recovering in hospital after a serious traffic accident where a big storm blew a plank from an advertising billboard through the windshield of his car. After emergency brain surgery and several days on life support, followed by a period in intensive care, he was moved to a private room. A journalist from the tabloid newspaper Sunday Sport then snuck into Kaye's room and interviewed and took photos of him before being thrown out by hospital security. Kaye, because of the ongoing effects of his brain damage, couldn't even remember the whole thing just 15 minutes later. But through friends, he tried to stop the tabloid from publishing the interview by suing them, basically arguing that his privacy had been invaded. The court, however, found that there wasn't any legislation or precedent to support such a right to privacy. Therefore, the only thing the tabloid was forbidden from doing was to imply that Kaye had somehow agreed to the interview or photos. But other than that, they didn't prohibit the publication of the story in any other way. Now, to their credit, the judges did argue that the case clearly showed that there was an urgent need for Parliament to legislate privacy protections in the UK so that this sort of case wouldn't happen again, but they argued that their hands were tied. In other words, precedent can only take you so far. It won't allow judges to make up new laws out of nowhere, at least when you're not a member of the royal family. Anyway, what this case really shows is that legal privacy protections often tend to clash with legal protections of other values like freedom of speech and freedom of the press. In fact, this is a recurring feature of 20th century privacy and one we can see popping up again and again in the law. So for example, it was a central issue when the now defunct Murdoch paper News of the World hacked into the phone of murdered teenager Millie Dowler, or in the way that several Premier League footballers have repeatedly used the English court system to stop tabloids from publishing details about their illicit sexual affairs. In all these sorts of cases, the question typically boils down to a balancing act between privacy and public interest. How much is protecting privacy worth? How much is public interest in the details of the situation worth? And which one should win out in whatever particular case happens to be under consideration? Now, if we zoom out from England for a moment, we can see that the increasingly expansive understanding of privacy over time, and to which extent it was considered to deserve legal protection, was happening elsewhere in the world as well. I won't go into the finer details of the development of, let's say, French post-revolution legislation or anything like that. Let's instead just jump straight into the middle of the 20th century. Shortly after World War II, in 1948, the United Nations unveiled its Universal Declaration of Human Rights. In it, Article 12 states that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. Although most countries of the world have by now ratified the Declaration, it lacks the force of law in the sense that there usually is no local law in a country that clarifies exactly how these sorts of human rights are protected or how the local courts are supposed to deal with them if they're violated. In this sense, the Declaration functions more as a sort of aspirational goal for international politics rather than a substantive law with real-world impact in specific cases. A more substantive approach was taken by the Council of Europe's answer to the Universal Declaration, the European Convention on Human Rights, from just 2 years later in 1950. The convention is interesting here because it also established a specific court, the European Court of Human Rights in Strasbourg, in which individual citizens can actually take their own country to court for failing to protect the rights enumerated in the convention. So, yes, if you've tried to use the local courts to protect you from some violation of your convention rights and they haven't done so well enough, well, then you can actually sue your own country for its failure. I'll say more about the court in just a moment. Now, like the Universal Declaration of Human Rights, the European Convention also includes a bit on privacy. It's Article 8, which states that every person has a right to respect for her private and family life, her home, and her correspondence. But they also add that there can be a bunch of exceptions to this general right, provided that the exceptions are in accordance with the law and necessary in a democratic society. What sorts of exceptions? Well, whichever ones are necessary for protecting things like national security, public safety, the general economy, law enforcement, public health, the protection of other rights and freedoms, and so on. In other words, just like in the English tabloid cases, Article 8 explicitly balances privacy against other values and interests in society. Now, I mentioned that the convention is a bit more substantive than the Universal Declaration of Human Rights, and although this is true, it's important to note that it still has some important limitations to how specifically it can be made to apply to individual cases. First of all, the interpretation and application of convention rights can differ a little between different Council of Europe countries, because of the understanding that they might have differing cultural views on some phenomena, so what's okay in Sweden might not be okay in Slovakia or whatever. And the courts accept that its rulings for one country might therefore not apply in others. This is called the margin of appreciation. And for this reason, it can be a little unclear exactly what Article 8 might mean in any given case. Now, although some guidance may exist in the form of previous decisions by the court, a lot of it is sorely out of date. You see, unfortunately, and as a second point, the court has an insane backlog of cases. On the latest count in late 2024, it was upward of some 60,000 or so still waiting to be heard. So therefore, the actual practical impact of Article 8 on individual people's privacy is in many cases still a little unclear. Now, if we zoom back in partway, this time to the European Union, then easily the most important legal privacy developments of the past few decades are the various laws that have been developed to protect aspects of personal information or data. This includes the EU's Charter of Fundamental Rights from 2000, which importantly includes not only a right to respect for private and family life, but also a right to protection of personal data. This was then carried further in a number of notable recent laws, such as the General Data Protection Regulation, or GDPR, from 2018, as well as the AI Act, which has been finalized but is only coming into force bit by bit over the next few years. I take it that most of you are at least a little familiar with these, and I'll have a lot more to say about them in later videos in this series. At this stage, it's worth noting just 3 things. First, the GDPR and AI Act focus on the protection of personal data, but in doing so, they also introduce their own balancing requirements, basically between protections of people's data, or the possible outcomes of AI algorithms on the one hand, and the acknowledgement that the processing of personal data and deployment of machine learning are today an important part of the global economy. Second, as legal EU instruments, the GDPR and AI Act must be implemented in full in each EU member state. So in other words, they have real force of law, as opposed to the more vague offerings of international agreements like the Universal Declaration, or even the relative uncertainty of the European Convention. And third, at least the GDPR has already had a huge impact on the way that big tech companies work. Among other things, it regulates the transfer of any personal data about people in the EU to anywhere else outside the EU, including the US. Again, we'll talk more about all this in later videos. Anyway, let's take stock. Both English and European privacy law has developed over time bit by bit in a way that has gradually expanded to cover a growing number of different sorts of cases. And the focus in the last couple of years has increasingly switched over to the impact of information technology on privacy and personal information, like in the GDPR and AI Act. And although we're still very much in the middle of these developments, a quick glance suggests that what happens next in this particular area will be extremely important in the sense that it'll impact all of us. To take just one recent example to illustrate this, a number of Swedish politicians have proposed in 2024 that the Swedish police should be able to use real-time AI face detection algorithms to track the location of wanted dangerous criminals. In practice, this would mean deploying the algorithms on things like surveillance video streams of public spaces, so that everybody who passes by there, you, me, your great-aunt Gertrude, will all have our faces automatically scanned and compared to the criminals. This is already happening in many places in the US and UK, but in the EU, the AI Act puts heavy restrictions on this sort of use, not least because we know that the algorithms have repeatedly misidentified innocent people as criminals. So there are real risks here for you and me and everybody else. Again, it's privacy as a balancing act, only this time in a different way. In this particular example, it's more about balancing the risk of innocent people being accused of vicious crimes versus the claimed needs of law enforcement to use AI algorithms to fight vicious crime. This is, by the way, also a clear example of why the focus on personal data and AI algorithms and so on is now such a central issue in discussions about privacy, and why most of this course is also focused on these questions. Basically, recent technological developments have completely upended much of what we, up until quite recently, had in mind when we were talking and thinking about privacy. Now, worrying about the impact of technology on privacy is nothing new. Information technology has certainly turbocharged it, but there have always been concerns about how privacy is threatened by recent developments. In fact, this is part of the legal privacy protection origin story in the US. Okay, let's rewind all the way back to 1849 and Prince Albert v. Strange. First and foremost, it's important to note that US common law at the time was still citing English court cases as precedent, so Prince Albert was still relevant to American courts. And this was particularly important to the argument of 2 young legal scholars in an article from 1890 called The Right to Privacy. This article would essentially single-handedly change the trajectory of US privacy law forever. The authors of the article, Samuel Warren and Louis Brandeis, were what we today might call, well, very concerned about the technological developments at the time. Basically, they were worried about 2 things. First, they were worried about the tabloids of the late 19th century, what were called yellow papers, and the way that they would print salacious gossip and rumors with very little oversight or regulation. Second, they worried about the recent development in 1888 of Eastman Dry Plate Company's so-called Kodak camera, a new technology that allowed point-and-shoot photography at an affordable price and which completely revolutionized media access to photography. And, more importantly, the Kodak cameras also suddenly made it possible to take photos of people secretly without their knowledge and without them needing to sit still and pose for the shot. So, papers printing gossip about affairs between different power players in society, and the added possibility of then backing such rumors up with secret photographic evidence. In Warren and Brandeis' view, these 2 factors together invaded the sacred precincts of private and domestic life and threatened a new situation where what is whispered in the closet shall be proclaimed from the housetops. And to some extent, these predictions held true, as evidenced, for example, by the case we discussed before, K.V. Robertson, from a whole 101 years later. Anyway, more interesting for us here was that Warren and Brandeis argued in quite an ingenious way. Basically, they argued that there was no need to legislate some sort of new right to privacy, but that its existence was instead already implied by existing precedent, and in particular Prince Albert v. Strange. In their view, what had originally served as a primitive notion of a right to life had over time expanded to include various rights concerning more than just the physical being of a person. These included protections not only from battery, so being physically beat up, but also from assault, so being attacked even when there's no resulting physical harm, or even if the attacker misses you entirely. Likewise, they discussed protections from nuisance and from slander and libel, as well as protections of both tangible and intangible property, such as trademarks and literary and artistic works. A legal right to privacy was then, they argued, only the next stage of this natural expansion of the common law. All the courts needed to do was to recognize this, and voila, a legal general right to privacy would be established in the US. They then went on to analyze what this sort of right to privacy would look like in quite a lot of detail, and thereby wrote the first real philosophical article on the concept of privacy, what it was, why it was valuable, how to protect it within the legal system of the time, and so on. Now, at first, the U.S. courts were rather slow to adapt Warren and Brandeis's recommendations, but they started doing so more over time. So by the mid-20th century, there were already hundreds of cases either directly or indirectly inspired by Warren and Brandeis. Then, in 1960, legal scholar William Prosser took the many cases and grouped them all into 4 basic categories. 1. Intrusion into a person's seclusion or solitude, so basically bothering others in their private space. 2. Public disclosure of embarrassing private facts, at least when it was done without any related threat, since then it would be blackmail rather than just privacy. 3. Publicity which places a person in a false light, that is, which gives an incorrect and probably harmful impression of somebody, like by quoting them selectively and out of context. And 4. Appropriation of a person's likeness. So, for example, using someone's photo without their permission for some stupid ad campaign or similar. Interestingly, in publishing this overview of privacy cases, Prosser was just trying to describe systematically how privacy case law had developed up to that point. But the effect of his publication was very different. It basically set in stone the way in which all privacy cases were considered from then on. In other words, after Prosser, the courts all referred back to his 4-part taxonomy when considering any relevant privacy case. Now, once again, this is where things start getting really interesting. Both Warren and Brandeis and Prosser show how conceptual research can impact legal practice in quite significant ways. But the really bizarre twist in this entire story belongs to the U.S. Supreme Court. So for those of you who don't already know, the Supreme Court in the United States has one main focus: to protect and apply the U.S. Constitution to the various cases it hears. And it has enormous power in doing so. For example, not only do all its cases constitute binding precedent in U.S. common law, it even has the ability to, for example, cancel existing legislation if it finds that the legislation is in conflict with the U.S. Constitution. The court consists of 9 justices who decide cases by simple majority, for or against. As I'm sure you can appreciate, given its immense power, there's a reason why both Democrats and Republicans are so obsessed with strategizing about how to get their own progressive or conservative nominations onto the court, even more than for the lower courts. But back to privacy. This is where it starts getting a little weird. You see, in 1965, the Supreme Court heard a very important case, Griswold v. Connecticut. The case concerned a state law in Connecticut making it illegal to provide contraceptives, so things like condoms and birth control pills, to married couples. The court found that the state law was in conflict with the U.S. Constitution and its amendments, but the different justices based their reasoning on completely different arguments. So Justice Douglas argued that this sort of right to a zone of privacy was a result of several constitutional amendments. The first concerning freedom of speech, the third concerning the protection of an individual's home, the fourth concerning protection against unreasonable searches and seizures, and the fifth concerning protection against abuse of government authority in legal procedures. All right, already this is a bit conceptually unclear, but fair enough. But then, in agreeing opinions, Justice Goldberg argued instead that this sort of privacy was a result of the Ninth Amendment, which states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And Justices Harlan and White, also agreeing, argued that it was based on the 14th Amendment about due process. So, conceptually, this was a complete mess. None of the justices seemed to be able to agree on where this constitutional right to privacy came from, even if they agreed it existed. And as if this wasn't problematic enough, the Supreme Court then went on to expand its conception of privacy numerous times, like in Eisenstadt v. Baird in 1972, arguing that the right to privacy protected the contraceptive and sexual choices of all individuals regardless of their marital status, or in the landmark 1973 case, Roe v. Wade, which found that the same sort of principle applied to the choice of having an abortion. Although, obviously, we need to note that in 2022, the Supreme Court overturned Roe v. Wade as precedent, so it no longer applies. Or, more important for present purposes, the 1977 case of Whelan v. Roe, which had no relation to the Roe and Roe v. Wade. Whelan v. Roe concerned New York state laws that required the collection and storage of information about certain sorts of drug prescriptions, including the name of the prescribing doctor, the pharmacy dispensing the drug, the name and dosage of the drug, and the name, address, and age of the patient receiving it. In its ruling in the case, the Supreme Court recognized a dual nature in its conception of privacy, arguing that one aspect of it concerned the individual interest in avoiding disclosure of personal matters, while the others concerned the interest in independence in making certain kinds of important decisions. Isn't that something? Privacy, starting from something like an extremely limited English legal protection of lawyers, that they couldn't be forced to testify against their own clients in court, had, through English case law, Warren and Brandeis, Prosser, and then Supreme Court case law, by the end of the 20th century come to mean both a protection against having all sorts of personal information revealed to others, as well as protection from interference with making certain kinds of important life decisions. But at this point, the privacy philosophers went a little crazy, as did many legal scholars too, to be fair. Essentially, there was an explosion of scholarship on the concept of privacy, and basically you could say all those who took part in this debate divided into two general camps. One camp thought that the latter important life decisions type of privacy was good and conceptually appropriate, and the other camp argued that it was fundamentally mistaken and proof only of the Supreme Court's conceptual confusion or even incompetence. In their view, these sorts of cases were perhaps about autonomy or liberty or something similar, but definitely not privacy. And so the debates between the two camps rocked back and forth for years, with numerous scholars adding their own suggested definitions of privacy to the mix. Now, I won't bore you with all the details about this here, but let's just say that the Supreme Court view of privacy, with its shaky conceptual foundations and gradually expanding scope, as well as the heated debate this caused, manages to nicely illustrate a very central and crucial issue regarding the concept of privacy, and that is just this. Different people or groups will do their best to define emotionally loaded and important concepts like privacy, a concept that many people in society are quite deeply concerned about. But who actually gets to decide what the definition ultimately should and should not include? After all, depending on how it's defined, that will then determine whether we can even use the law in the first place if we feel that our privacy has been violated. So the definitions make a real difference to whether or not the courts will support our claim, like in Prince Albert v. Strange, or tell us to get stuffed, like in K.V. Robertson. Now, fortunately, there's a lot more to say about this question, about who gets to decide how to define privacy, but that, my friends, is the topic of the next video. I'll see you there.